Hello, good morning to all the joinees. I am Srivalabh Patil from Sapient 12. This is our 12th year of completion at Sapient 12. And as always, we try to do new sessions or new events for all of our clients. And this time it's no different. Being an investor, you already started your journey of financial planning and financial independence. But we often forget about will,
भाई तू तो बाहर में
succession,
तू फैब्रिकेशन
and
ना
legacy
वेल्डिंग
planning.
हाँ
We often forget about will, succession, and legacy planning. Maybe because we don't think about it, or maybe because it's a taboo topic. Today, we would like to discuss about this topic and educate all our clients regarding will and succession plan. I would like to introduce today Mr. Vivek Sadle, a founder partner at Legalogic. Vivek, if you could turn on your screen.
Can you see my video?
Yes.
Okay.
So Vivek sir has 25 years of extensive experience in M&A, takeover, private equity, will succession planning, trust. He started Legalogic in 2013. Prior to that, Vivek sir was company secretary and a general counsel at Persistent Systems Limited. Vivek sir is a chartered secretary, UK. He is a company secretary and he is a CMA management accountant. I would like to hand over the mic now to Vivek sir. Vivek sir, all yours. We have more than 200 participants who want to listen to willing with the willpower. Over to you, sir.
All right. Okay. Thanks, Vallabh, and good morning, everyone. It's a pleasure to talk to each one of you. I know how important this topic is, and I also know that this is a Saturday, so this is a premium time for everyone. Let's make use of it. Unfortunately, in Maharashtra, at least in Pune, where I and Vallabh live, we again are on a weekend lockdown. So there could be nothing better than talking about how to preserve the wealth that you create. And while Sapient and Vallabh and his team is continuing to create wealth for you, the idea also is to make sure that the wealth passes on in the most right manner. And that's the motivation of creating this session for all of you. And thank you for joining in large numbers. I will try and keep this session. I saw a chat note when someone said, speak in Hindi. And I will try and use non-legal words as much as possible. I also will try and ensure that to the extent I'm able to answer the questions in Hindi or Marathi, I'll try and do that, but bear with me. It is tough for me to translate what I practice into a different language than English, but I'm learning. And I'll hopefully after this session, I would have gained some words which I can use in later presentations in either Hindi or Marathi. So this is all for you in terms of what this will topic is all about. Vallabh used this word taboo, and you know, in any if you look at all of these things, we when we
can
are
you just bother you for a minute?
Yes.
Can you just make a co-host in my name or Sapient Pune,
Okay, one second.
so that we can do a spotlight?
I don't know how do I 1 second.
हेलो अभी
1 second. I'm just trying to do that. Give me a minute.
Just go to participant.
I don't see that enabled. Is there a way to do this? I'm not able to find that.
You can continue.
Okay. All right. Okay. So here you go on the will with willpower, and the reason. Let me step back. And what I was trying to say is that any of these topics which is related to will, think about the Euro football which is going on right now. While the football is the focus, but there were two things that were outstanding in the first few weeks, few days that Euro started. One was obviously a champion had cardiac arrest, and there was a lot of buzz around what happened on the ground. And beyond football, there was a spotlight on something which was different than football, and that made more news than the football itself. And the second thing was the moving of cold drink to a water bottle created havoc on the stock market for that particular company's stock. And think about ESOP, and you then feel that there is Narayan Murthy's driver who got ESOPs at Infosys, and then everything around ESOP moves with this particular perception in the minds. And similarly, if you look at will, and those who are in late, born in 60s and 70s and 80s, and on this particular call will clearly remember the way the Bollywood movies played out the will. And it is, and some of the advertisements as well, and created a buzz around, will being something like taboo, which what Vallabh mentioned a few minutes back. And similarly, there is another concept and perception in our mind that will is for some business tycoons and with someone who has large amount of wealth, and then only those people need to create will. And all of these things with time obviously have changed, and the mindset for everyone who has wealth, and the wealth is a relative thing, and the wealth and preserving that wealth also is a relative thing. How you would want to take your wealth, enjoy your wealth to yourself and beyond you to whom is something which is now gaining a lot of traction overall in the mindset of people. And that's exactly why we are with you today on this topic of will with willpower. Again, just a quick disclaimer, this is not a legal advice, but it's a general guidance. The reason why I'm saying so is that many a times I have seen people relating a particular conversation in such a way that it becomes like a legal advice, but for your specific situation, do seek a specific professional guidance. Otherwise, it could turn out to be a difficult task for yourself. So look at all of this more as a guidance and more as an education rather than legal advice in itself. I'm going to talk, as I said, not legal language, but something which is for everyone to understand, appreciate, and want to make sure that you all take home why do you need to create will and what are the nuances related to the will that you need to keep in mind. It's a very simple document to make, provided you create that willpower in yourself to make it happen. I'm sure all of us know this name, Princess Diana. She died a very tragic death at a very young age, but even in that time frame, she had, and she continues to rule the minds of large number of people. And when she died, remember, she was all of 37 years of age. she had created the will. And when she created the will, as her will stated, her estate went to her children. They were minor at that point in time, and therefore there was a guardian appointed, and someone took care of that estate till they turned major. And then she also gave something to her former butler, who was one of the beneficiaries of her estate. So the point is that in the will, it is your will and wish that you actually are able to do it. If you don't do, then the law takes over, and the law will decide as to how your wealth is going to go, and not your mind. And remember that, you know, your mind has so many things, but if you don't document it, the law says that while, you know, you're gone, then the law will take over. That is, the government process takes over, and then there are rules of the game defined, and accordingly in the Indian Succession Act or Hindu Succession Act, depending on which religion are you from, it will essentially have an impact in terms of how your wealth devolves. And that's one of the critical reasons as to why you create will. And you are essentially trying to not just protect your assets, but you are making sure that your family legacy and your ideology is essentially documented properly. This is the most critical aspect of it. Think about it, that, you know, you earned so much, you worked so hard, you enjoyed your life, and for one small little, what I call as laziness, or you know, not putting pen to paper, you might have a situation where you leave your legal heirs or your you know, intended beneficiaries through the will that you could have created in a lurch in some sense. This obviously helps in preservation of wealth. More importantly, one of the things that I have you know, often been asked this question, that there is no dispute in the family, so why should we create a will? Remember that the, you know, the will is created to ensure that the legal heirs, आपके जो legal heirs हैं, they are able to enjoy the property without much ado after you are gone. In India, for small little thing, as you have seen, it takes a long time, and unless you are disciplined in terms of making sure that your financial assets are also taken care of in the way you have worked hard to create those financial assets, it can become a really daunting task for you and for your legal heirs. And therefore, when you don't have disputes, it becomes imperative that to protect the time and bandwidth of all your legal heirs, your children, you must create this will. Think about it. Most of you would have someone or the other who's intended beneficiary outside of India, residing outside of India. Now, hamare sabke ghar mein, there is at least one or two people who are residing outside. They're either working, doing business, or you know, your daughter may be married and residing outside of India. And or for that matter, if you are in Pune and your children are outside of Pune, it's the same impact as if someone is outside of India. And then you are looking at a situation where they will have a torrid time. And we have so many cases that come to us where the mother or the father or both are no more, and the children are really gasping in terms of even identifying what these financial assets are. And then you have a situation to handle. One of the other things that we'll do is, while you're preparing, one of the things that we advise all our clients is to prepare what we call as an inventory of all the assets. And when that inventory is created, you then have that financial discipline of at least getting everything together. And then you are essentially making sure that your legal heirs clearly understand what all assets have you created in your lifetime. We just had one very unfortunate situation. A young lady who is a Singapore resident, she lost her husband. And you know, this gentleman was fairly young and successful, both. And that was the reason that, you know, it is really shocking. But unfortunately, he expired about a year and a half back, and his assets are both in Singapore and in India. He did not keep a clear inventory. Wife obviously is a professional. She understands some of these things, but still, remember, mark my words, the wife is a professional. She's a chartered accountant. She knows about the finance, but she does not know what all did husband invest in, including some cryptocurrencies and in some places where it is password protected. And with him, because it was not documented, some of the wealth is gone forever. And it's such a shame that while you created all of this for people that you love, and they are the same people who are not able to enjoy after you're gone. And that is one of the reasons that you would want to create a will, to ensure that all your inventory, all your financial inventory is at one place. We always believe that "Arey mujhe kya hoga," which is a correct thing to assume all the time. But mujhe kya hoga is always fraught with challenges. We don't know mujhe kya hoga. And the second thing is that we always think and assume that someone in my family knows what I am doing. But remember, that could be a piecemeal. It may be Vallabh, who's your financial advisor, who would know most of the things, but not all things. And if you want Vallabh and his team to know everything what you have, either you hand over everything to him so that he understands that it's a complete thing. But remember, you have jewelry, you have your two-wheeler, you have a four-wheeler, and you have so many other things that only you or your family would know about it. And therefore, it is important that to collect everything together as what we call as a financial inventory and plug that in as part of your will. And this is one of the important things that what will achieves. And this is something that I have personally learned over a period of time, that will not just creates a document for later succession or estate planning, but also is an extremely good way of creating a financial discipline. I would want all of you to think about it from this aspect as well. It's not just about the death. It is about making sure that you are financially disciplined and collating all your data at one place, which will help you in the long run. Also, very, very important thing is that the will is an extremely tax efficient mode of transferring your property to someone that you love, who is the beneficiary of your property after you. Because there is today no inheritance tax, and even if the inheritance tax comes, it will come with a threshold, which means that beyond a certain level of assets, only those assets will become taxable as inheritance. And therefore, it becomes important to understand that will could be extremely, extremely useful instrument when you are looking at your tax planning as well. During your lifetime, you can gift, and I'm going to talk about it, but importantly, with will, even non-relatives would possibly inherit this with the most tax efficient, in the most tax efficient manner. And last but not the least, what you do with the will is save the time and bandwidth of your loved ones who are intended beneficiary of your assets and your wealth. And simply that aspect of it, think about it, if someone is in the US and has to come here for doing all of these things, remember, things are slow, and in these COVID times, they have become really, really slow on the procedural matters. It could be daunting task for your loved ones who are not with you, especially those who are not living with you, to manage all of this after you're gone. And what are we talking about? We're talking about these three things. And obviously, if you're running a business, it creates a different approach altogether. And there could be family arrangement, there could be certain other aspect, but I'm limiting my conversation to these three aspects today: gift, will, and private trust. And these are, you could use them in isolation, you could use them in combination, you could use all of these three as as a mechanism of making sure that you are passing on your personal wealth in the most right manner. And then, obviously, there are situations where you are dealing with businesses, and those businesses have to be looked upon separately. Obviously, that is your biggest asset. If you're running that as a majority shareholder, that becomes your biggest asset. But for the business, there are different considerations, and because of paucity of time, I'm not intending to touch that in detail. We're happy to have questions if you have as we go along. On just a quick time check, we're going to run this till 12:15 or so. I'm going to continue to speak for another 20-25 minutes, and then we'll open up for questions. Vallabh is collating questions, and he will pose those questions as time goes by. Vallabh, feel free to stop me when you think it's appropriate time for Q&A, even if I have not run the complete presentation. So we're talking about gift, will, and private trust. And what is a gift? Gift is something that you would want to give to your loved ones during your lifetime. Remember that the will kicks in only after your lifetime, but the gift is something that that you can give, and you keep giving, right, on the birthdays or anniversaries or college graduation and what have you. You keep giving it, but gift as an instrument of succession planning and estate planning is also a very, very important mechanism. For example, you have multiple immovable properties, and you want someone else to also benefit from that during your lifetime. The tax, the stamp duty impact is very minimal if it is to your blood relation, and if it is to your immediate family, then in Maharashtra, the stamp duty is only 200 rupees. There is a registration fee that you need to pay, but still it is a tax efficient and administratively efficient mechanism of passing on your wealth during your lifetime. Many a times people come and say, while we would want to keep most of it to ourselves and pass it on after our death, but there are certain things we would want to pass on at a particular juncture. And the way to deal with that is to say in your will that this is what, because you don't know what happens tomorrow, and therefore you put that as a part of will. And suppose, of course, the idea is that you will survive that particular period. And after 2 years, after you've created the will, your son passes college, and or he's getting married, or your daughter is getting married, and you want to give them something, then even though you have written that as a part of the will, because you are, the will kicks in only after your demise, you have control over your assets, and you can give out of those assets whatever you want, and make sure that, that succession planning and the estate planning continues as such. The only thing that you must remember is that once the gift is given and the gift is accepted, the same cannot be revoked at all. Okay, once it is given, then that becomes the right and the ownership of the person to whom you have gifted, and it cannot be taken back unless that person again transfers it or gives it back to you. So I mean, that's something that you need to be clearly aware. But don't neglect gift in the overall planning as you do, because that could prove to be another tax efficient way of dealing with it. Remember, on the income tax, there is no tax at this point in time. So to that extent, you could benefit when you are transferring or when you are gifting to the family as defined under the income tax. I'm now going to talk about the will. And this is one of the most effective methods of estate planning. One of the most effective, one of the most easiest, one of the most what I call cost efficient manner as well. It does not take much cost for the kind of property and wealth that you're talking to transfer as such. So what are the constituents of the will? The will is essentially a written document. Important thing is it is a written document, because remember, The will kicks in only after you are no more in this world, and therefore it has to be a written one. It has to be a signed one, and it is your last wish essentially. And it could talk about multiple different things. Remember, what people write in the will is not just about the property. They also write about their life stories, saying, who's helped them, and therefore you're compensating as love and affection. Uh, Compensating is not a right word, but you are, effectively providing them some financial benefit who may not always be your family. You have the ability of doing all of this through the will. You could donate to some NGO. You could say that after I'm gone, certain sum of money, 10 lakh rupees, should go to this NGO. Or you could say, my driver helped me, like the butler story of Princess Diana. This gentleman helped me, or this lady helped me in the house, and I want to leave something to that lady. All that is possible to be clearly identified and documented in the will. But important thing is that the will has to be a written one. You need to sign that particular thing, and then you are essentially giving all of these things. You could distribute all kinds of properties and assets. It could be movable or immovable. It could be cash. Movable means cash or something related to that. Or it could be immovable, which is your house property, your land, and what commercial properties and whatnot. If you're giving it to your children, then and they are minor, a guardian can be appointed in the will in terms of who will guard those assets till the children turn major, and then the children can enjoy that particular property. You could also provide for your last rites. People have been writing in the will in terms of organ donation, in terms of eye donation. What do they want to do with their social media account? Many times there is this fear that someone can just hack your Facebook account or Twitter handle and whatnot, and then it could be misused after you're gone. And to that extent, there are wills now we are starting to see where the social media and the passwords associated with it are also being mentioned in terms of where have you kept those passwords, where do I, if I'm an executor of the will, where do I find that? All of this. You also can talk about your pets. You can talk about charity, as I mentioned to you, and you could talk about the interest and management of property of your minor children and whatnot. So essentially, anything that comes to your mind, which is in existence at the time when you are writing the will, which is your property and which is your asset, can be willed in that particular document. What we like to suggest is that create that inventory, make sure that you have identified all of your assets that you would want to pass on, your two-wheeler, four-wheeler, and so on and so forth, your jewelry. And, jewelry is in India as one of the bigger concerns in terms of how do you identify if you have, multiple jewelry items. And of course, a woman in a house would possibly remember everything. But then when it comes to the will, the whole idea here is to ensure that the will writes down in clarity and with clarity as to what happens to some of these items, how you identify. You can take a photo of those jewelry items, mention where they are put in. If you're using them on a daily basis, you could say so. If they are in the locker, you could say so. But importantly, think about all of those which are precious things for you, and you would want to pass them on more as legacy and emotions. And that's something which is an important thing. Remember, will can be created on a plain paper. You don't need to put any stamp duty. You don't need, so there is this myth that the green paper, the ledger paper, what you call as a legal paper, it needs to be on that. Nothing of that sort. You could create a will on a plain, simple paper. You could type the will. You could write it by hand. You could do, multiple. You could write something. But keep the will in a consistent manner, and of course, sign those as such. Also, remember the will that you create, you can amend it as many times as you want during your lifetime. Okay, you could cancel your will, you could create a fresh will, you could modify the will, what we call as codicil. I have a slide on that. But remember that what you create is not permanent at all, because your life changes. People who are beneficiary, for example, your daughter marries and has children, or your son marries and has children, you would want to give something to your grandchildren at a later point in time. So obviously the will is not a static one that you have created at once and then it is done and dusted. You can always modify and ensure that the reality that exists in your mind at that time is reflected in the will. And therefore, one of the suggestions that we have is to reflect on your will every now and then, periodically, maybe every 3 years or what have you. That's something which is an important thing to remember. But no stamp duty, no other formalities required to be done. And therefore, this is one of the most simplest of documents that you could create in one sense. So what is the essential? What is the essential? You need to be of majority age, which is 18 plus in India, and of course of sound mind, which is important thing. And I'm sure you remember a lot of Bollywood movies where there have been scenes created where the person was not medically capable to write the will, and that has been taken as a defense in the court, saying that उनके तो हाथ भी नहीं काम कर रहे थे, उनके तो हाथ थरथराते थे, and then therefore he was not in his senses to be able to sign the will, and this is not his signature and it's a forged signature, and so on and so forth. So remember that it is important that the person is of majority age, which is most of the time fine in terms of looking at it, and you are looking at a person of sound mind. How do you justify that? You justify that by taking a medical certificate from a doctor and attach that to the will. Many a times, young people don't need to do that, but those who are senior citizens, we are advising them just to avoid any hassles at a later point in time, not from the family, but even from the banks and the other financial institutes who might have question because your signature changed on the will and so on and so forth. It's best that you have a certificate from doctor to support that. We talked about the fact that it has to be in a written manner, it has to be signed. Important thing is that the will is to be compulsorily witnessed by at least 2 people. Okay, the act, the Succession Act, and the legal provisions in India make it mandatory for will to be a valid will to have a witness, to have 2 witnesses. And one of the practical suggestions we therefore give, and the important importance of the witness is, if suppose at some point in time the will is disputed or a probate is to be taken, at that point in time the witness may have to show in the court to say that what they have witnessed is the final will. And therefore people who are younger than you, relatively younger than you, should be selected as the people who are the witness, and they are important. Don't take any random people as the witness just because they are easily available at the time when you are creating the will. Take people who are trusted and who will withstand, one, the scrutiny, if at all it comes from the court, and 2, importantly, that they are younger and the probability of this surviving you is more as such. You can always change the witness next time you create a will. It is not necessary that you compulsorily have to have the same witnesses. You could obviously change those witnesses every time you create the will. That is not a problem at all. And again, this term is an important one. When you are gone and you created the will, there are 3 sets of people that we are talking about. One is someone who is the beneficiary. जिसे आप आपकी संपत्ति दे रहे हो, the people who are going to benefit out of your wealth, who you have named as the beneficiary in the will. Second is the witness. I just told you about why witness is important. And the third important person is the executor, the person who will ensure that the property transfers from you to them and make sure that the people who are named as the beneficiaries get exactly the share what is expected out of the will, and they are the people who are actually the executors. If you don't write the executor, then the legal heirs, themselves can distribute if there is no problem, that is done and dusted. Or if there is a bit of issue in terms of determining what the properties are and who will do all of that, then you can go and apply to the court of what we call as an administrator, and the court will appoint an administrator through what we call as letter of administration. And then to that extent, you then have that person who will be administering the distribution of wealth to the beneficiary. But the easiest part is to create an executor in the will itself, so that you avoid this particular ambiguity. And these are some of the nuances that you don't want to forget, because if you do, then even though you have taken the pain of documenting it, it may not be legally tenable. Obviously, many a times this legal aspect does not come where there is nothing amiss in the family, there is no dispute in the family. But if there is, then that could essentially have a problem. And as I said, there is no stamp duty payable on the will, which is important thing. So don't worry about if someone were to advise you that 500 रुपए के stamp paper पे करना है, 100 रुपए पे करना है, 1000 पे करना है. This is all not correct. There is no stamp duty that you need to pay on a will that you create. So what is end of the day? What does will do? Will essentially takes away the right under Indian Succession Act. So the Indian Succession Act has a particular way in which the property will get distributed. If there is no will, there are set rules of the game and you can't change them because they are cast in stone. But in the will, you have ability to override, and no one can question you as to why are you doing what you are doing. But importantly, you can actually pass on what you have created on your own, those properties as per your will. That is the most important thing. You avoid and surpass what law would otherwise provide, and therefore creating this will is an important one. And I have provided for those who are governed by Mohammedan law, the personal law prevails if there is a conflict in terms of the will and the personal law. And to that extent, it's best to take legal advice while you are doing some of these things. Codicil, what is codicil? Codicil is nothing but it's a supplement to the will. It's an amendment to the will, and you could create as many codicils as possible. You want to change something, you can do a codicil and make that particular change. You can bring in some properties that you have bought new, bring in more assets in the will that you have identified that were not part of the earlier thing. You want to change the beneficiaries. All of that is something that you could do. And everything we spoke about the will, in terms of that it should be written, witnessed, and so on and so forth, all of those apply similar to what they apply to the will, to codicil as well. And that is something that you would look at doing it. And while it's one of the recommendation is that you should attach a copy of the will to the codicil, which means that you have one full document, and then someone who's an executor at a later date doesn't have to scramble to find out where is the main copy and where is the codicil. The both documents are read in tandem and together as such. So here are the best practices that you should keep in mind. One is that while it is not compulsory to register, we recommend that you register the will, because remember that the will registration is a private affair. It doesn't expose you from public scrutiny. There is a register which is maintained as such, but the contents of your will are a private document and they are not exposed to public. The will does take away the this issue of the Bollywood movie most of the time, saying that whether the person who actually signed the will was he the real person, and so on and so forth. So many of those things, ifs and buts, go away. That is an important thing to remember. Second thing is that on a practical level, it is important that you create nominations in such a manner that they align with the beneficiary. So for example, if you say that in this bank, all my savings or all the balance in this bank account will pass on to A, B, or C, make the nomination in the similar manner so that it becomes practically easy for the executor and the legal heirs to enjoy the assets upon your demise without much ado. Nomination that is not equivalent to transfer. Nominee, the person who is a nominee, only is keeping it for the benefit of the beneficiary. But remember, if you are the beneficiary in the will and you are also the nominee, then to that extent you avoid the ambiguity, and then you are able to use the assets immediately upon the demise of the person who was the creator of the will. And therefore, it's important for you to align this nomination to the beneficiary. The other important thing is husband and wife should create wills simultaneously, but we recommend separate wills because you can always create a joint will, but there are issues in the joint will. And as a law firm, we are recommending separate. But once the husband creates, the wife should also create the will, because generally what we have seen is, and this is the right way of doing it as well, that the husband says that beyond me it passes on to my wife, and beyond wife then it will pass on to my children or whosoever you think appropriate. And the wife would say the same, that beyond me it is to my husband, and then to if the husband doesn't survive, then to whom. So it is important as to creating these both wills simultaneously. Otherwise you are again still keeping some ambiguity around it, but create separate wills even if you create it simultaneously. As I mentioned, to ensure that you take away again that Bollywood situation of whether the person was of sound mind or not, you are essentially doing a doctor's certificate. I mentioned that you must periodically renew your will, either completely as a new will or as a codicil. We are recommending 3 years. You could do it yearly exercise. You could do it once in 2 years, once in 3 years, up to you. But do revisit the will every now and then, just so that your most updated mind and updated will is actually documenting what is there. And again, this is not a sales pitch, but importantly, the Google can only do so much. Your case is peculiar to you. It is a customized thing. It is your property, and Google does not know, hopefully does not know, it knows more than what it needs to, but it still does not know what is in your mind. And to that extent, whenever in doubt, seek proper tax and legal advice so that you're fully satisfied and you're fully covered on all of these aspects as such. What happens if you don't do the will? And one of the most important thing is that the law takes over. Remember that if you don't keep the will, then actually the law takes over. Let me simplify that. What do I mean? Obviously, if the intended legal heirs have in themselves a understanding that we understood that my father said, my mother said that this will go to you and all. That's a practical approach. But the financial institutions, mutual funds, and so on and so forth, they don't rely on, the legal heir statement. They would expect a succession certificate to come from in the name of the legal heirs. And, the succession certificate takes time in the court to be gotten, and to be, you need to spend both time and money obtaining it, because the law takes over. And, you are saying that this is how you would want to do the succession. And to that extent, the legal heirs, names, etc., come into play. It is clearly a leakage of time and money, and it can be avoided by simply writing a will. And to that extent, think about it. When you spend this weekend in a lockdown, spend some time. It is not about you passing away or you in the best of health at this point in time. It is just about being disciplined in terms of creating this. I'm going to run the private trust little quicker, looking at the time. And many people may not be interested in looking at private trust, but you've heard about will, I'm sure, but you may not have heard about private trust, and therefore I want to talk about it to ensure that you have this back of your mind, especially those who are running businesses and are looking at estate planning, to look at this from a holistic standpoint. There is a settlor, there is trustee, and there are beneficiaries. Settlor is a person who is creating that particular trust. Think about it, that you are the person who's creating the will. You could be creating the trust as well, and therefore you are a settlor. There are trustees who are actually the managing, the trust like an executor. And then there are beneficiaries who will benefit out of the assets of this particular trust. So what is this? This is not a charitable trust at all. So first thing in mind that you need to remove is that you need to go to charity commissioner. No, not at all. This is a private trust, which means that no public scrutiny asset. It is your personal trust. This is your private trust, and no one else will have any iota of ability to peep into your home to find out what this whole thing is about. But still, it is considered from tax perspective as a separate legal person. And to that extent, a trust is a mechanism where when you have a shareholding in a company, or you have an immovable property that you are looking to pass on, जो हम लोग बोलते हैं कि पुश्तैनी जायदाद है, and we want to pass it on to generation. This could be a mechanism where the beneficiaries are able to enjoy the fruits of the property, but cannot dispose of unless the constitution gives a certain right to the trustees to do what they want to do. But remember that the beneficiaries can enjoy the properties, and therefore one of the mechanisms is, suppose you want to say that my shares in a company should not get sold unless ABC conditions are fulfilled, what we call as the bylaws of the trust, the constitution of the trust. The constitution of the trust will define as to when and how the beneficiary will be able to enjoy the assets that are situated in the trust. What we are recommending to many people is that when you have a shareholding and you want to pass it on to your son and a daughter, or two sons or two daughters, or combination of any of this thing, and you want someone to actually do day-to-day management of the business, someone else will be a passive one, and all of those conditions you could very, very articulately put in, legally enforceable. These are all legally enforceable. Tax to be paid, etc., etc. So they are all above board situations. People are using trust to insulate against the impending, we've been hearing this for a long time, that there could be an inheritance tax that can come, and the private trust mechanism is utilized to actually do a lot of structuring of your assets in such a way that you might get a shield from inheritance tax. We don't know as yet, but people are saying that what worse can happen if I keep it to myself. In any case, I have to pay inheritance tax. So at least let's try and create a private trust that could be a mechanism to shield against an impending inheritance tax as well. And remember that the trust can be revocable or irrevocable, which means that you might want to have a control depending on how life moves, whether you want to continue the trust on a perpetual basis, and therefore you're creating an irreversible, or rather irrevocable trust, or you're creating something which is a revocable one, should you have a different thinking in mind. And remember, the tax treatment is different, accounting treatment is different when you are creating a revocable and irrevocable trust as such in one way. And you could create trust on a standalone basis. You could create trust through a will. And there are various mechanisms of structuring all of these things. But all of this structuring would depend on what kind of assets you have, what is the value of the assets, is this adding to your administrative burden? If it's a simpliciter assets, a simple will can do. If there are shares and if there are immovable property that you would want generations to enjoy, then the private trust could be a mechanism to deal with. And then obviously you would want to understand how the beneficiaries of the trust can enjoy the property. You can put the rules of the game as a part of the constitution of the trust, and then you could write as elaborately as you would want on some of these things. I'm coming to my final leg of the presentation, and then I'll take questions. Women and NRI is another important constituents. Remember, in India, women traditionally have got neglected from the estate planning, right? And again, we have seen this shadi kara di, abhi ab usme, the girl has no particular interest. And even now, it pains when we hear some of these things. Obviously, it is to everyone's way of thinking and how they would want to do it. Some people tell us that, look, we have given what we had to at the time of the marriage, and we will continue to do it during our lifetime, but there will not be any inheritance. The law has started to look at it a little differently. So Supreme Court in the recent judgment in 2020 clarified that women also have an equal right in the assets of their fathers and husbands, HUFs. Very, very important judgment that came recently. And remember, because of the complicated law of a woman who's married and woman who's not married, creating a will for a lady is actually a priority than even a man. Because if you read through this, when a Hindu married woman dies without a will, then what happens when she dies? And husband has predeceased her, what happens, and so on and so forth. It's very complicated in terms of, and that may not be the intent of the lady, and therefore the lady in the house and those who are today listening to this particular webinar, you must take the lead and create your will. My experience shows that women, they understand some of these things in the Indian context, understanding of what they want to do and why they want to do. Is just that they are a little reluctant to write it down for obvious cultural reasons. But I guess those are the past times. In these times, it is important for a woman to create a will. And if the woman doesn't create one, it can have, serious, not serious from that sense, but it could have multiple repercussions under law because it's to that extent complicated as such. I'm sure there are a lot of non-resident who are on this particular webinar or whose children may be non-resident in India. Remember, our advice is that succession law are country specific, right? What we have in India is not true in the US, is not true in UK. So you must draw your assets country-wise. And in each country, you must write a will which is in tune with the law of that particular land. Simple. I mean, the distinction is very simple in my mind that when you are a non-resident Indian and have properties in multiple different countries, then in each country, you must write a will for the assets that you have in that particular country. Very important. The other aspect is the beneficiaries could be a non-resident Indian. Now, under the foreign exchange regulation, there is a separate provision in terms of how much a person can take as what we call as repatriate the funds outside of India. And to that extent, you have a situation where you could have $1 million that can be taken in a financial year as an inheritance out of the wealth that you inherit if the beneficiary is a non-resident. So what am I suggesting and what am I recommending? I'm recommending those who are non-resident and creating will for themselves or their children and advising their children to create the will for the property in India is to ensure that they do will per country and not combine it as such. And then, you could put in your removable property, you can put in movable property. The rest of the things would remain the same as such when you are creating this particular will. A probate is, I'm sure you've heard to a large extent about a probate. A probate is nothing else but a copy of will which is certified by the court to say that this is the authentic copy and there's nothing beyond this particular will that exists. And in Mumbai, Chennai, and Kolkata, where people have immovable property, obtaining a probate is mandatory. In rest of the country, it is not mandatory. So the statement, as you see the last, where probate is not essential in case will is registered. So, the registration comes from that perspective as well. You then don't need to go through the probate process. I'll stop here and then, let me take questions. Vallabh?
Yes, sir. Hi. I just want to thank you for such a crisp session. I guess it is very difficult to cover that vast topic on wills and succession. And from the questions, I can understand how complex the topic is. But this is really good. By the time I was writing questions, the slides were explaining the answers. So most of the questions were answered. But there are a few questions which were repeated, which I would like to ask you. One is a very basic question or very important question. What age should you have a will?
Sorry, can you repeat that? I couldn't listen the last sentence, Vallabh.
At what age should you write your will?
Okay, very, very important question. Actually, I should have brought that. I think our suggestion is that as soon as you have a family responsibility, you must create a will. As soon as you get married, we go to astrologers, we do all of that jazz in terms of, shadi and, what we call as a big fat wedding, which is all good. And, we should all celebrate that. But along with that, it is important that you do two things. One, you have an insurance policy and you have a will written. Because if you don't, then all of what I said, if you don't have the will, and if you are a Hindu married woman or a Hindu married man, how does it translate is an important thing for all of us to understand. And therefore, the age is, regardless of the age, it should be looked upon as all adults should create one. But as soon as you get married, you must, definitely create one. And if you are not married and are have a significant share in the property or have created property, today the marriage age also is, earlier 30 ke pehle everything was done, and today, at least in metro cities, we are seeing 30, 35 is the normal marriage age. So if you have created properties even before the marriage, it's not a bad time to write a will. So it is never right or wrong time to create a will. Today is the right time is the answer for all those who are participating, and those who you want to pass on the message, tell everyone that the time of the marriage, and there's nothing as a taboo that, that someone is talking about, "Arey yaar, shadi kar rahe ho, will ki kya baat hai?" But it is actually an important one. Both the insurance and the will and the nomination changes. All of these three things is something that you should talk to your financial advisor as well, to your lawyers, to your tax advisors, and I'm sure each one of them will give you the same answer.
Brilliant. Very well answered, sir. Thank you. Next is that you already answered, if you have assets in different countries, better to create will according to the local law and divide your will as per the country. There is question which was repeated is, can you create a digital will for people who are residing overseas and who want to make a will for their Indian assets? How can they do it sitting overseas?
Yeah, sure. So they can create a will in the place that they are residing at this point in time. They need to only ensure that the assets in India are noted in the will that they create, and specifically for the Indian context, and ensure that the will is available for the executor at the time when the execution comes into play. So nothing changes. You could be anywhere, or you could create the will. The will could be created on paper and then kept in a digital mode, scan and kept. All of that is no hindrance in the law at this point in time, Vallabh.
Okay, brilliant. Next one is, what if someone has a special child? Would you recommend them to have a private trust or the trust structures which we explained, or how would they go forward?
Oh, no, absolutely. Excellent question. And I think, the private trusts are used for various purposes, including for special situations. It could be, I'm on a ship and I want to ensure that my parents are, protected to a certain extent. And then I create a trust. I have a special child, special sibling, and I want to create a trust. All of that is definitely something that the trust can very clearly identify and ensure. It could create what we call as an annuity income, Vallabh, and that's something that you could utilize trust to do it. The trust mechanism is a very potent one for all these special situations that come in someone's life if someone is looking at that. So creating a trust is not just for succession planning in a normal situation, but it can cater to special situations as well. I did not go in depth on the trust simply because most of the people may not have interest on the trust, but for anyone who has a special need or have a special thing to create an annuity income for various purposes, trust can be utilized. I can talk to you separately as well.
Brilliant. I think so. We'll stop here because there are a lot of questions which go in depth on legal and legality. But as you rightly said, being a Google investor or a Google legal person is not a right idea. It will be a good choice to consult for the detailed questions that I have seen on the chat box. So I think we'll stop here. I hope everybody liked this session. I can see it from the chat box that people have appreciated the way you covered each and everything in such a short time. I thank you for coming here and explaining will and succession planning for all the Sapient clients. Thank you very much, and we'll be in touch if any one of us.
No, so thank you, Vallabh. Thank you so much. I appreciate you putting this together, and I wanted to thank my two team members, Vikas Agarwal and Aparna Bede, who both have helped me and and bear with me on all of this particular thing. It is an important thing. Help your family, all of you, when they need you the most, at the time when you are around and at the time when you are not as well. So thank you so much for participating, and stay safe.
Vivek, just one thing, that if people want to contact you, should they write to us and then we get in touch with you, or how do we take this forward?
So both things are fine. They can write to you. That may be an appropriate way. They can write to me on my email ID as well. My suggestion to everyone would be to route it through Sapient, simply because they have a good understanding about your wealth and the planning that you are doing. and one intervention can help filter some of your answers before you come to me. But I'm happy to answer any of your technical questions that you might have at any point in time.
Yeah, so I have put in the chat box the email ID for everyone's benefit. So if you have any query or you want to take up with preparation of the will with Vivek, then you can write to service@sapientwealth.co.in, and then we'll be happy to connect you to Vivek. I think the cost, the tenure, and all of that you can discuss with Vivek directly. You can put an email to us, and then we will ask the Legalogic team to get in touch with you. So thank you, Vivek. And as they say, where there is a will, there is a way. So you have shown some way to people for probably taking the first step in passing on their hard-earned money to others. So thank you very much. And all the patrons of Sapient, on a Saturday, taking time out for your own money is of course beneficial. But next Saturday, we are going to do a session on startup investing, wherein how to create that money and then take Vivek's help to transfer that money to your next skills is what we are going to discuss on the next Saturday's event. It's on startups with Nilesh Shah of Kotak and with Anuj Bolcha of Venture Catalyst. So do attend, the details will be sent. So thank you, Vivek, and thank you everyone, and we'll close the session now. Thank you.
Thank you, Vallabh. Bye.